Good evening, and thank you for attending this online version of the Equal Opportunity in Housing Program that we try to hold every year. I think we missed 1 year, but so thank you all for attending. For those that don't know me, I'm David Sartorana, and I'm the chair of the Litchfield County Chapter Council of the Greater Hartford Association of Realtors, and I'll be your moderator this evening. I'd like to take a moment and just thank Cheryl Ann DeSalvo, our Director of Chapter Services, for putting this together. As usual, she's done a fine job. She keeps me informed and keeps me so I can do this for you. And so not knowing who's in the room, I'm just going to say a few people that that may be in the room. Holly Callanan, our CEO, is here this evening. Susie Larson, the Vice Chair of the Litchfield County Chapter Council, and also Rob Zabo. He's one of our councilmen. So thank you guys for being in supporting this. You know, it's an important program that we do. So I'm going to introduce the speakers one at a time. We're going to give them an opportunity to give their presentation. Our first speaker, I'm going to introduce Salmun Kazerounian, and he's the staff attorney at the Connecticut Fair Housing Center. So thank you for attending tonight, Salmun.
Thank you so much, David. And thank you to the Greater Hartford Association of Realtors for having us tonight. I want to talk tonight about applicant screening, which is an issue I've worked on for a number of years now. Before I dive in, I'll start with some background. The typical way we think about discrimination under the Fair Housing Act is when a landlord or another housing provider intentionally discriminates against a specific group or explicitly treats one group less favorably than another. This is called disparate treatment. But under discrimination laws, there's another form of illegal discrimination that's called disparate impact, which prohibits policies and practices that have a disproportionate adverse effect on one group or another, even if the policy on its face treats everyone the same way. In the context of screening your applicants, this plays out a number of ways. Perhaps the most widely known is screening prospective tenants for criminal history, which many folks are aware of because of the 2016 HUD guidance on the use of criminal history in applicant screening. But what I want to talk about, well, let me give some background on that. Decades of research have shown that people of color are significantly likelier to have criminal records, and accordingly, screening policies that restrict access to housing based on criminal history have a disproportionate effect, disproportionately exclude people of color from rental housing. Today, I want to talk about an analogous issue that will continue becoming more and more prevalent as the eviction crisis continues to ramp up and families are forced to relocate. Specifically, I want to talk about screening applicants based on their eviction histories. I suspect most folks attending tonight do some form of eviction record screening, and that's fine. But I want to inform you all of some of the potential pitfalls and hopefully avoid you some liability down the road. Just like criminal records, people of color are significantly likelier to have evictions filed against them than white people. And extensive research has also established that women are likelier to have evictions filed against them than men, and women of color above basically anyone else. This means that when you screen applicants for eviction history, a disproportionate number of people of color and women are rejected. That's not to say that there are no circumstances under which you can screen for eviction history. Under the Fair Housing Act, after it's been shown that a policy has a disproportionate effect on a protected class, like people of color or women, that's not the end of the analysis. Next, the burden shifts to the landlord to prove that the policy that's being challenged has a non-discriminatory reason for existing. In other words, the landlord would have the opportunity to establish that the policy is justified. But that justification can't be based on stereotypes, it can't be speculative, and it needs to be sort of concrete evidence that a person would make a bad tenant in this case. But can you assume that anyone who has an eviction filed against them, or who has had at any point in their lives had an eviction filed against them, would make a bad tenant? What if, say, the eviction was filed and it was withdrawn? So the landlord filed the case and withdrew the case, or it was dismissed, or the judge found, like the landlord claimed the tenant failed to pay rent, and the tenant showed the judge their receipts and proved that they paid the rent on time. That case would likely end in the tenant prevailing. But many landlords and realtors have policies that basically don't look beyond whether or not an eviction record was filed. And there are other circumstances, like, well, let's say a tenant had an eviction filed against them after losing their jobs due to a disability before they were approved for disability benefits. Can you say for sure that person would make a bad tenant if you rent to them today? Or what if someone had an eviction filed against them because, you know, they failed to pay the rent after they were laid off during the Great Recession in 2009, 12 years ago? Can you assume that person would make a bad tenant if you rent to them today? What about someone who was evicted for non-payment because they lost their jobs during the pandemic, but now they have a Section 8 voucher that will cover the bulk of their rent? Does that person's eviction record indicate that they'll make a bad tenant? Well, of course, you know, people fall on hard times and circumstances change, and often people recover from those hard times, and as a result, you know, a past eviction record doesn't necessarily indicate that that the person would fail to meet the obligations of tenancy if you were to rent to them today. So what that means is basically that the landlord's policy needs to be justified by some sort of rational relationship to a person's suitability for tenancy. So if a case was withdrawn or dismissed, or a landlord or a judge did not make a finding that a landlord violated the lease, then that eviction record itself bears no information about whether or not the tenant failed to you know, pay their rent at their previous unit. All it shows is that a landlord, you know, claimed that they did, or suspected that they failed to meet the rental obligations. But the eviction record itself does not give you that information. And withdrawn or dismissed eviction, as I mentioned, does not give you any information about whether a landlord or whether a tenant violated the lease. What this means is that your policy needs to be tailored to screening out those tenants whose eviction record actually demonstrates that they present a risk to violating the lease. And that's not, you know, a blanket case across the board. You need to tailor that policy to ensure that it doesn't exclude people of color and women beyond those who are actually potential risks to your business. Even if you have a more tailored policy that looks at the outcome of the case or looks at the circumstances surrounding a case, the burden would then shift to the tenant or the plaintiff to establish that they have a non-discriminatory reason for having that policy. I'm sorry. To establish that there's a less discriminatory alternative to the policy that's being challenged. Excuse me. So what that means is that the tenant can show, well, there's a better way to do this. You don't need to reject everybody with this type of eviction record, even everybody who has an eviction judgment against them. What you could do is look at the individual circumstances surrounding a specific person's eviction record. So if a person tells you, yes, I was evicted a couple of years ago, but it was because I was laid off and I've been consistently employed since, and now I also have a Section 8 voucher, and my son is living with me and he also has income, then rejecting that person based on their eviction history alone would not get you further toward your goal of ensuring that those people who are actually able to meet the obligations of tenancy are able to rent from you. What it does is it excludes a large swath of people from your housing who some of whom may have legitimate reasons for being denied, some of whom may actually be bad tenants, but many of whom may actually just have circumstances in their lives that that in the past have caused or maybe a landlord even made up an allegation against them to try to get them out of housing. A lapse of time eviction or no cause eviction is a similar sort of scenario, where if you're evicting people for no cause evictions, for evictions where even their landlord could not come up with a justification, a reason to allege that they violated the lease, then if you're rejecting people who have been evicted just because their lease expired, then that will necessarily result in a significantly larger number of applicants of color and women being denied from housing who are perfectly qualified to rent from you, either because they now have a job that they didn't have at that time, or they have a Section 8 voucher. In fact, I've been fighting with a landlord the past couple weeks who is rejecting somebody who had an eviction filed during the pandemic, and now has a Section 8 voucher. That eviction record based on non-payment of rent has no relevance whatsoever to whether or not her circumstances have changed so significantly that you cannot look at any moment in her past and say that this indicates that she would be incapable of paying rent at her current unit, because now her rent is completely tied to her income. She'll never pay more than 30% of her rent with this voucher. So there's simply no basis for the rejection. And if they follow through with the rejection, we are likely going to file a complaint for race discrimination based on the blanket denial of people with eviction records. And I want to help you all avoid a similar sort of fate in the future. Just make sure that your policies are evidence-based and look at someone's actual suitability and ability to meet the obligations of the tenancy. The simple fact that an eviction has been filed is seldom enough to give you that information. And so I encourage you all to look well beyond that. I will leave it there and take any questions.
Thank you, Salmun. I don't see anything in the box, Sherilyn. Nothing, no. All right, so that'll give people time to think about your presentation. Again, thank you. And hopefully they can come up with some questions before we end. So next, we're gonna move on to Rashida Rattray, and she's from the Connecticut Fair Housing Center, and she's their education and outreach coordinator.
Good evening, everyone. Thank you again to the Greater Hartford Association of Realtors for inviting us into this space to be able to present this evening. So one of the things that I'm going to touch on, the main thing that I'm going to touch on this evening is going to be Unite CT. So I'm sharing my screen now, and I am going to go from the beginning. So this is just a general overview of the Unite CT program, just kind of things that you need to know with regards to it, application and who can apply and, eligibility requirements. So jumping right in, Unite CT is a program that is administered by the Department of Housing on behalf of the U.S. Treasury, and it provides up to $15,000 of rental and electricity payment assistance on behalf of Connecticut households that are financially impacted by the COVID-19 pandemic. This program is specifically for renters, people who rent in the state, and their landlords. Unite CT's goals is to stabilize the rental housing market by financially supporting those households that are up to 80% of HUD's area median income, so their AMI. There are also eligibility requirements or, certain eligibility for individuals that live in certain census tracts. So as far as, what Unite CT covers, the funds help to cover with rental arrearages and or rent going forward with a new landlord. Arrears is defined as money that is owed and should have been paid earlier. So Unite CT will help to pay for utility and rent arrears. This means Unite CT will help to pay for money owed in utilities and rent payments. The date for the funds to be spent is currently September 2022, to the best of my knowledge, and we have a little bit over $400 million to distribute to renters and their landlords here in the state of Connecticut. So who can apply to the Unite CT program? The individual must qualify for unemployment or have experienced a reduction in household income or incurred significant costs or experienced a financial hardship due to the COVID-19 pandemic. They demonstrate a risk of experiencing homelessness and housing instability, and they certify that household income is at or below 80% of the HUD area median income. The Unite CT website is very interactive, and on that website they have a map where you're able to, glide over each town and city in the state of Connecticut and kind of get a better idea of whether you fall into the census tract or an area that is below that 80% AMI. People who are out of status are also eligible to apply for the Unite CT program. You do not need to have a social security number or ITIN. You do not need a government ID. You do need a government ID, but it does not have to be a U.S. issued government ID. You can also apply through the Unite CT website, and you're eligible for the same benefits as everyone else. If there's an applicant that is currently receiving any other federal or state housing assistance, they are also eligible to apply for the Unite CT program. Public housing is housing that is owned by a public housing authority, and subsidized housing, including housing voucher holders, are also eligible to apply for Unite CT. So how you do that is you access their online portal. Here is a link to it. You can even type into Google Unite CT application, and that is one of the first links that pops up. Both the tenant and the landlord need to have email addresses that they can access. I know that there's some landlords that I've worked with while I was working, some of the Unite CT bus events that did not have email, and people at the events were willing and able to help them set up an email address, an account that they were able to access so that they can complete their side of the application. Tenants do have to provide a photo ID, while landlords have to provide their property information, ID, W-9, proof of ownership, a copy of a lease agreement, copy of the statement of arrearages for the tenant, and also their bank information so that they can receive the funds. For these documents, pictures can be taken on a smartphone or tablet and uploaded to Unite CT's document matrix. There are also self-attestation forms. For example, for the lease agreement, there's something that can be, there's a form that the Unite CT folk have usually on the bus that they could pull up and, kind of strum up a form, a lease agreement if there's not one that's currently existing, that the landlord and tenant can then sign and then enter into that matrix. So they've really stripped down the process for people to be able to apply for this program because they really want to get the funds out, and there is a great need for them. So for applying for the program, Unite CT does have a call center that can be accessed for password reset and general questions. The number is provided here. This PowerPoint will also be provided to you, as well as this recording will be available to you to access. There are also 16 resource centers across the state that can provide one-on-one appointments and services to applicants. We do get sometimes people that are frustrated and not sure how to apply, are not tech savvy. So having those resource centers really help so that people can interact with others and get the help that they need to fill out that application. Lastly, Unite CT has a mobile bus that travels across the state and is equipped with computers, iPads, and staff ready and willing to help applicants. They do also have a schedule of where the bus will be, and that can also be found on the Unite CT website. So you could scroll all the way down to the bottom. It's going to be past that map that has the 80% AMI. You're able to see where the bus will be and be able to access contact information for whoever is, having the bus come so that you can get questions answered. You can also schedule appointments through that matrix. So let's say you know that you're going to be free at 2 p.m. You could schedule and hold a spot for you so that you're able to access that. There's also an interactive dashboard that is on the Unite CT website that highlights how much money has been given out, how much money is pending, and kind of, in each town and city area of the state of Connecticut, how those funds have been distributed. So just touching on a concern that is often brought up with tenants that are fear of being evicted for non-payment. Before starting an eviction for non-payment, landlords are required to apply for the Unite CT program. That is through Executive Order 12D. So if there are tenants that you know of that are facing eviction but have not had access, or their landlords have not applied for the Unite CT program, please encourage them to reach out to legal services to be able to kind of get assistance with that. Also, Unite CT should be seen the same as other protected subsidies, such as Section 8, SSI, and SSDI. A landlord cannot refuse a tenant just because they're using Unite CT as a form of payment. That can be seen as source of income discrimination. So here's our contact information, and I've provided all of the links to the Unite CT homepage. There is a turnaround time for applications once they're submitted. This ranges. It can be anywhere between 30 days to maybe 2 to 3 weeks for the application to be processed and then the funds to then be processed. You are free to contact that Unite CT email that is provided here in the slide. Or if you've filled out an application and you have been granted a caseworker or auditor, they will let you know who that person is, and then you can feel free to contact them with regards to the status of your application. We really do want people to access this money. It's here to help people to catch up on their rental arrearages or to be able to have rent for a new property going forward. So again, I just want to thank everyone for allowing me into their space and allowing me to present. And I am going to check the chat box to see if there are any questions. So I see a question that says, had a tenant of mine that applied owed me back rent because she was out of work due to COVID. She applied and never heard from Unite CT. After 2 months, she eventually moved out. If you would be able to provide her information with regards to that, because she could still be able to access that Unite CT funds to pay for the rent going forward to where she is right now. And if she did apply for those funds while she was currently living at your property, she should still be able to use that money to apply to her arrearages. So definitely would like to have her contact information so that we can forward her to the right people over at Unite CT that'll be able to help her with that.
Good answer. Thank you.
Thank you so much.
Yeah. Oh, wait, there's something in the chat room here. Oh, great job. Yes, thank you again. All right, so then last up, we have Jeffery Sussman, who's the director of the HUD Boston office.
Hey, hi, or how's everyone doing? Just bear with me 1 second as I share my screen here. I want to make sure I get the right screen. Looks like you should all see my screen now, so I will get started. As David said, my name is Jeffery Sussman. I'm the Center Director for the Office of Fair Housing and Equal Opportunity at HUD in Boston. Our office is responsible for enforcing fair housing laws throughout the entire New England region. So what we do is eliminate housing discrimination, promote economic opportunity, and achieve diverse, inclusive communities by leading the nation in enforcement, administration, development, and public understanding of federal fair housing policies and laws. And that's what brings me here today. As I'm sure you all know, Title 8 of the Civil Rights Act of 1968, better known as the Fair Housing Act, prohibits discrimination in most housing transactions based on race, color, national origin, religion, sex, disability, and familial status. Anyone involved in housing transactions, such as property owners and managers, maintenance staff, and real estate agents, must comply with the act. Because real estate agents are integral in facilitating the majority of housing sales and rentals, you're often the first ones who can spot possible discrimination. HUD values your partnership and recognizes that every day you do all you can to follow the law. But when you don't, HUD and our partners at the agencies we fund through the FIP program are there to watch.
For 3 years, reporters at the Long Island, New York newspaper Newsday put hidden cameras and microphones on investigators and sent them out to pose as home buyers. They wanted to see if real estate agents treated white, black, Hispanic, and Asian buyers differently. The differences were stark. Newsday's investigation showed that agents steered minorities away from mostly white neighborhoods and showed them fewer listings. Black homebuyers were most likely to be discriminated against.
So you might have seen this story. It was a big story about a year ago now, maybe 2 years, year and a half actually, about some testing that was done that looked at real estate practices and found that there's a fair amount of discrimination going on. And those practices are not limited to just Long Island, where this study was. Fair housing groups, often funded by our Fair Housing Initiative program, are out there doing testing throughout New England and the nation. And here's one recent example from our region here in New England. This was in the Boston Globe. You'll see there in the bottom corner, strong bias against Black renters seen. In July 2020, this study came out and it involved testing. You send a pair of folks to apply for housing, one of a protected class, one not of the protected class, and you compare treatment. They did this match pair testing at a bunch of properties to look for several things, such as whether testers were able to make appointments to see properties, how many units housing providers told testers about or showed them, whether housing providers offered financial incentives, whether housing providers made positive or negative comments about housing units, and whether housing providers offered testers an application. In this case, an organization we fund at Suffolk University Law School called the Housing Discrimination Testing Project did this study. They assigned 200 individual testers to contact the housing providers of 50 different apartments in the greater area that were randomly selected from common rental property listing sites from August 2018 to July 29. And it made a lot of noise here in Massachusetts, and I think wider than that. And here's why. 71% of the tests showed evidence of discrimination based on race. that's significant. You know, here's one article about it also from the Globe. And there's a quote here from Bill Berman of Suffolk University, who runs that testing program. We at HUD did not fund this through our funding for nonprofit organizations. However, they got funding independently to do this work to support their mission. And he wrote, real estate professionals are part of the problem. You know, and he said, but they should be part of the solution. So working along these lines, we continue throughout the country to do more studies and support more of this work to figure out where this is occurring and what we can do about it, especially in our region. So know that this stuff's going on, and I know of at least one other instance of such a study going on right now. So there's people out there looking to make sure that housing opportunities are provided fairly and equitably and in accordance with the Fair Housing Act. I also want to talk about a few other things because there's been some notable news, some developments at HUD in the last year that are worth talking about here in this fairly quick presentation I'm doing that's just on some high level stuff. But I think it's really important that we look at this. Just this February 11th, our office, the Office of Fair Housing and Equal Opportunity at HUD, issued a memorandum stating that HUD interprets the Fair Housing Act to bar discrimination on the basis of sexual orientation and gender identity, and directed HUD offices and recipients of HUD funds to enforce the act accordingly. The memorandum began the implementation of the policies set forth in President Biden's Executive Order 13,988 on preventing and combating discrimination on the basis of gender identity and sexual orientation. It directed the executive branch agencies to examine further steps that could be taken to combat such discrimination. And HUD was the first agency of the federal government to expand, as a result of this executive order, the protected classes under a law, the civil rights law they enforced when they expanded the Fair Housing Act's definition of sex to include sexual orientation and gender identity. This memorandum relies on the department's legal conclusion that the Fair Housing Act sex discrimination provisions are comparable in text and purpose to those of Title VII of the Civil Rights Act, which bars sex discrimination in the workplace. In Bostock v. Clayton County, the Supreme Court held that the workplace prohibitions on sex discrimination include discrimination because of sexual orientation and gender identity. HUD has now determined that the Fair Housing Act's prohibition on sex discrimination in housing likewise includes discrimination on the basis of sexual orientation and gender identity. Accordingly, and consistent with the executive order, we now enforce the Fair Housing Act to prevent and combat such discrimination. We're also requiring the state and federal enforcement agencies we fund under the Fair Housing Act's Fair Housing Assistance Program to do so as well. So we fund all these state agencies. Some states like Connecticut have already had protections in these areas, but much of the country does not have these protections. But now the federal government's and our enforcement at HUD of the Fair Housing Act is able to step in there and also do these cases ourselves and provide funding for our state agencies. In Connecticut, it's the Connecticut Commission on Human Rights and Opportunities. We can now fund their investigations into sexual orientation and gender identity issues with this more expansive definition of sex. One other thing, there we go, next, sorry, this slide. Another area you may have read about is our work on appraisal discrimination. You've probably seen stories recently about home appraisals are lower in Black and Latino neighborhoods than in white neighborhoods. The recent Freddie Mac study, summarized in the article to the left, found that the appraisal gap seems pervasive in lowering home value determinations in Black and Latino neighborhoods. This study over there reviewed over 12 million appraisals. And this study's not alone. Data suggests that homes in Black neighborhoods are appraised at lower values than similar homes in white neighborhoods by as much as 23% on average. This gap seems to be growing. Therefore, in response, HUD, where I work, is co-chairing a task force. The secretary herself is leading this along with Susan Rice, the director of the Domestic Policy Council, to research this issue and make recommendations within the next few months on how to address this issue. The first listening session on this subject was held with several groups last Thursday, and the work is moving along promptly. So this is an area of focus right now in fair housing at HUD. And it's really got in the eye of the secretary. So it's at the highest level of the department. We're really seeing movement on some interesting areas that you know have maybe not seen as much attention in recent years. But I think it's also time to look at some of the stuff that's going around in New England that involves some real estate agents and topics that might be of interest to you all. So we'll start with Portland, Maine. All right. So this case here that's on your screen came to HUD's attention when Pine Tree Legal Assistance, they're a FIP of ours in Maine. They filed a complaint alleging that Page Realty LLC and Ramona Venskus discriminated based on familial status when they refused to negotiate with fair housing testers posing as families with children, posting discriminatory advertisements indicating that children were not allowed, and made discriminatory statements to fair housing testers. The order resolving this resolved the charge that HUD reached of discrimination against the owner and the real estate agent. Under this order, Page Realty LLC and Ramona Venskus had to pay Pine Tree Legal Assistance $18,000. In addition, they had to attend fair housing training. In Providence, Rhode Island. So on February 11th, 2021, so not that long ago, we charged a large landlord in Rhode Island, D&D Realty Management, with discriminating against families with children in their rental properties. This case was brought to us by a FIP in the region, South Coast Fair Housing Inc., who completed a series of tests on the respondent. The testing evidence revealed that respondent would not rent to applicants with children, and each time a tester informed respondent that they had a child, the viewing would be canceled and communication would cease. Additionally, respondents made statements to testers with children that children were not allowed in the units and that respondent could not accept children. The testing evidence showed that testers without children were shown the same units and offered the opportunity to rent with respondent. Respondent was able to show that they did not rent to one family with a child, but this was only done after they were on notice of the complaint filed by FHEO. On March 15, 2021, these parties entered into a settlement agreement in which the respondents agreed to affirmatively advertise to families with minor children. Respondents agreed to move language from their website that guarantors are required for all applicants and to change their policy to limit guarantors based on income threshold. Respondents agreed to notify off-campus housing and student living offices at 3 colleges in the area that students with children were welcome at their properties. Respondents had to ensure within 6 months that all employees there received fair housing training at their cost. And they have to notify our partner, South Coast Fair Housing Inc., within 30 days of receiving any complaints regarding housing discrimination. In this case, respondents had to pay $10,000 in compensation. And in Massachusetts, Fair Housing Center v. Cammons, another case brought by one of our FIPs, testing in a large complex based on advertisements by agents marketing it as a student property, although it had nothing to do with the university. Testing showed that the agents were steering persons with children away from the property, suggesting other properties in nearby towns that they felt were more family friendly, and only scheduling tours with persons without children for the subject property. This case was ultimately settled and the respondents agreed to pay our FIP partner there, the Massachusetts Fair Housing Center, $12,500. Respondents agreed to affirmatively advertise to families with minor children, and respondents will alert the Fair Housing Center in Massachusetts when they have an available unit for the duration of a year. Respondents are going to receive training, and they are going to understand that testing is likely to occur on their property going forward. And if there are any issues, the U.S. Attorney's Office is aware and is ready to look at them. So there's a few things, a bunch of different things that might be of interest to you today. This is a version of a presentation that I've given that's more like 2 hours. So I cut a lot out of it for you today to get into this 15-minute time frame, but there's a lot of interesting work going on right now in fair housing. If you have any questions or you know anyone who wants to file a complaint, here's the information to file a complaint. And here's my information. You can give me a call, you can email me, and I'm happy to answer any questions now. So thank you for having me.
Thanks, Jeffrey. I don't see anything in the box, but maybe, I don't know if you guys, we're 40 minutes into this. I don't know if anybody wants to, one of the presenters, maybe raise your hand. A couple of topics that we could talk about were legitimate source of income, service or comfort animals, and maybe security and pet deposits.
Well, those are all very interesting, weighty topics. Source of income, I can't really speak to so much because we don't have that protection over at HUD. We encourage all of the entities that we fund to take vouchers, and we administer the voucher program, but we don't have that protection under the Fair Housing Act. But that's something that the state of Connecticut has under the state law. I don't know if we want to start there, maybe. But I don't want to put Rashida and Salmun on the spot.
Yeah, no, and definitely not. I just thought if there was, obviously some of these topics could be, another 15 to 30 minutes each. But I just didn't know if there was anything that by talking about those topics, if it brought anything to you guys that maybe you wanted to discuss.
I think one thing I will say is that we have seen more cases in the last year filed with our office than we've seen in any year in recent memory. More people are coming to our office to file complaints. Disability is very much the number one issue or basis that we see in our office among people filing complaints. However, we have seen an uptick in race complaints recently, and we'll see if that continues. So comfort animals, support animals, and reasonable accommodations generally are the most common issues that we see. I'm happy to answer questions on those subjects if anyone has questions, but it's almost too big a subject for me to just start on and just talk about,
Understood.
I agree,
Totally
Jeffrey.
understood.
It's really a big topic to kind of try to think around and without much of a prompt. But I will say that individuals that do have disabilities are protected under the Fair Housing Act, as well as source of income in the state of Connecticut is a protected class here. When it comes to source of income, if there is, legal income, that is a housing subsidy, SSI or SSDI, and even Unite CT as funds that are being used by the tenant to pay for their rent, the housing provider cannot flat out deny them and say that they will not accept them based on that. We do get a lot of questions with regards to the difference between emotional support animals and service animals and comfort animals. And honestly, under the Fair Housing Act, there is no distinguishment. There's no difference with regards to that. If there is an individual that does have a disability and they have paperwork that can verify, which is, a letter that comes from a treating medical professional, not particularly a doctor, MD, but if they do have documentation or requested documentation from a housing provider to prove that they need this service animal, comfort animal, support animal to be able to maintain their quality of life, then a housing provider cannot deny them that. So they cannot deny reasonable accommodation or modification requests. We do see a lot of disability discrimination calls here at the Connecticut Fair Housing Center. I believe last year about 60% of the calls that we did, the intakes that we did receive were disability discrimination complaints. So it is still something that is happening. And if there are any questions with regards to that, we're happy to answer them. But I hope I helped and provided some info.
You certainly did. And I think the thing that we can take away from this is, both of your organizations are available to the people that have questions or have complaints, and they can certainly come to you, and we can direct them there. That's what we should be doing is help them as much as we can. But if they have the bigger questions that we can't answer, then they certainly need to come to you guys to get those answers. So thank you. Yes, that was very helpful.
Absolutely.
I see nothing else in either the Q&A or the chat box. So I guess at this point, I'm going to say thank you to everyone again, those out in the audience that we can't see, and to Salmun, Rashida, and Jeffrey, who I can see, and certainly Cheryl Ann. Thank you all for attending tonight.